The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, be seated, please. All right, first case we'll call this morning is Smiley versus Botnagar. And Mr. Costello, I think you're up first.
Good morning, and may it please the court. My name is Tom Costello. I'm here with my partner, Ann Preston, and we represent the 5 appellants in this matter. The 5 appellants in this matter prior to January 2019 were the founders, majority shareholders, directors, and officers of a corporation known as Mphase. Plaintiffs filed a complaint alleging that Mr. Botnagar fraudulently induced them to turn over the management control of Mphase to him through a series of misrepresentations made over a months-long negotiation. Mr. Botnagar negotiated directly with—
I gather you call them misrepresentations because they really were promises that he didn't comply with.
Yes.
The only way they became misrepresentations is if he never had the intent to comply, and that's not alleged.
We do allege in the complaint that he acted with a fraudulent intent when he made those misrepresentations.
But that's a rather conclusory allegation. What are the specific facts that support misrepresentation and related to the inducement?
Well, in the complaint, we pleaded alternatively. We say he made them intentionally and or negligently.
Well, either way, you've got to plead, I think, at least to get past Twombly, some facts that support those claims. You just can't say he lied to me.
Well, his actions showed that he lied to him. His
actions showed a breach of the promises made in the agreement. So what's the evidence that he actually never intended to perform those promises from the get-go?
Well, I think the complaint spells out that the plaintiffs made the requirement that no convertible debentures be issued without a price floor time and time again in the negotiations, and Mr. Botnagar time and time again in those negotiations said he wouldn't do it, and then in fact signed a document that said he wouldn't do it in his individual capacity.
He breached that agreement. So again, I'm asking you, what is the evidence that he never intended to perform?
That the issue was brought up repeatedly, and he made repeated assurances that he wouldn't do it, and with months of taking control of the company, he did it.
Isn't that just a repetition of a promise that he made? In other words, he says, I promise I'm going to do this, I promise. And that's totally consistent with the idea that he intended that.
I think if someone is made clear to someone that you cannot do X, and he promises repeatedly not to do X, and then he based on those promises, he takes over control of the company and does X, and while he does X, continually lies about why he did X, then yeah, that inference can be drawn from the complaint, and that isn't sort of the basis for Judge Grimm's decision in this case. The basis for Judge Grimm's decision in this case is that this is a derivative injury, not a direct injury.
And you're right. I mean, he didn't rely on that ground, but you know, we can, I guess we're not required to, affirm on any basis apparent in the record. And so my concern, and it appears that of my colleague, is that these allegations just appear to be rather conclusory and really don't allege anything more than a breach of an agreement. And the problem with that is that your clients weren't parties to that agreement, and that the agreement itself suggests that it's the corporation and not the individual plaintiffs who have to bring that lawsuit.
Well, I believe the allegations of the complaint make clear that they were fraudulently induced based on those oral representations. Yeah. It's also not a defense that the appellees raised in response to the complaint. And I would point out in the complaint, we point out who said the misrepresentations, Mr. Botnagar, when he made the misrepresentations, who was present when he made the misrepresentations.
You keep calling them misrepresentations. I mean, at that time, they were framed as promises, and your clients relied on those promises. That's not a misrepresentation of fact.
I think that's for the fact finder to determine, because intent is a question of fact.
Tell me in the complaint. I read the whole complaint, and the only thing I read about fraud is that he was a conclusory statement there. but I didn't see any facts saying at the time he made those representations, he never intended it because of this or that, and some evidence suggested something that you could prove to say that his promise was totally manipulative and was never intended to be fulfilled. And he actually came later and probably provided some explanations as to why he did it or found it necessary to do it, but that all goes to the breach of contract aspect.
Well, again, I mean, his actions allow the fact finder to make the determination that he acted with a fraudulent intent. Because when somebody brings up the issue multiple times before they commit, and then within months after committing.
He could have said it 20 times. I promise, I promise, I promise. You can count on me. And the other guy says, I'm counting on you. And he signs this. Those documents are pretty peculiar. Your clients, I don't know. Well, I don't want to comment.
Right. So, well, I think his actions do support a finding of fraudulent intent. Again, this is at the...
Well, the complaint. Give me a paragraph that you think.
If you look at the allegations of the complaint, essentially from pages 14, paragraphs...
Give me a paragraph. Your best paragraphs.
15. And then he goes on to continue to when the plaintiffs discover that he's done that, they go to him and they ask him, why have you done this? And again, he falsely states that, don't worry, the debentures won't be exercised. We have money to pay that off. And that was another false statement because they didn't have money to pay him off and the debentures were exercised.
Well, the statements you allege there are just promises, right? You allege two statements. For the period of 3 years, Botnagar would not cause M-Phase to engage in any sort of financing transactions, and Botnagar would utilize future monies raised by the plaintiffs in private placements to satisfy outstanding liabilities.
And he did not, he took the money and then he used it for something else. I mean, that's also evidence of a fraudulent intent. So with regard to that issue, again, that's not something that was raised by the defendant. It wasn't something that was adjudicated by Judge Grimm.
Well, it's something on which you're relying, isn't it, to reverse the district court?
We certainly feel like our clients have suffered a direct injury because...
No, my question is that something you're relying on this appeal to reverse the district court?
What I'm relying on in this appeal to reverse the district court is the allegations in the complaint that show direct misrepresentations were made to my clients.
Yeah, okay, fair enough.
Okay. So in Judge Grimm's opinion, we feel like he made an error in saying that this didn't form the basis for a direct action. We feel that's error because Mr. Botnagar made these representations or misrepresentations to my clients directly. My clients, in reliance on those misrepresentations, ceded control of the company to him. They not only suffered...
Set aside the fraud claim. Set aside the misrepresentation allegation. The district court basically concluded that your claim was grounded on contracts to which your clients were not party. They were contracts in which the corporation was the party, and that in order to allege damages caused to the corporations, you'd have to bring a derivative action. I think that's where the court was, wasn't it?
I would respectfully disagree.
Okay, well, clarify that.
Sure, because nowhere in Judge Grimm's opinion does he talk about the contract, or does he say that my clients aren't a party to the contract or don't have a right to enforce the contract. Judge Grimm's analysis is simply, you're a shareholder, part of your damage claim is loss of diminution of value, therefore you have to bring a derivative claim. And we feel that that's contrary to the New Jersey law that applies, that specifically says a shareholder who was directly misrepresented by a director or officer of a company has a direct action against that individual. So Judge Grimm's opinion, in my reading of it, respectfully, doesn't get into the contract at all. Sort of back to...
I think he did engage with these cases that you cited from New Jersey, but he concluded that those cases involved closely held companies and this was not.
He did say that, and that's something that we also feel respectfully that the trial court didn't quite get right, because he doesn't cite any legal authority that defines what a closely held corporation is. There's no authority that says if it's not a closely held corporation, then it has to be, and it's a
What's
public.
your understanding of a closely held corporation?
The only definition that we found, okay, was in the IRS regulations, which indicates 5 or more people own a controlling interest in the company, which is exactly the situation and what we exactly alleged in the complaint.
Well, but didn't you allege that M-Phase was a publicly held company?
It is a publicly traded company.
So those are two different things, is what you're saying?
Not necessarily, not according to the IRS. If it's a publicly traded company and 5 people own a majority stake in the company, then it's considered a closely held corporation.
Even though there may be over 10,000 shareholders?
If those other shareholders don't amount to a majority, then yes.
That's not closely held. I mean, closely held, it seems to me, at one point, one of your 10Ks, you had 23,000 shareholders.
There are numerous shareholders, but there's no definition.
A public company with 23,000 shareholders, you're arguing, is a closely held company.
If you apply the IRS regulation of 5 or more people controlling a majority interest. But, when we look at the public policy reasons that require derivative litigation, there are basically 3 factors. One of those factors is that we don't want some shareholders benefiting from the assets of the corporation while other shareholders don't. They view that as unfair. This isn't the situation here because we're suing Mr. Bhatnagar individually. The other public policy consideration, which requires derivative action, is to make sure creditors of the corporation aren't treated unfairly. That's not the situation here because we are not trying to attack the assets of the corporation. The third consideration is the protecting the company from a multitude of suits. And there's absolutely been no allegation or evidence that's been presented that any other litigation's been brought other than by this core group of plaintiffs. So when you look at the public policy considerations that require derivative litigation, none of them are present here.
Let me ask you this. Are the damages you're claiming the diminution in the value of the stock based on the conduct of Mr. Bhatnagar?
That is one component of our damages. The damages we've alleged in the complaint are not only the diminution of the value of the stock, the loss of my client's salaries and fees as officers and directors, their personal debt obligations that M-Phase owed to them, which they agreed to convert into equity based on Mr. Bhatnagar's misrepresentations. So there are multiple categories of damages, and the damages that have to do with the loss of the debt, loss of the salaries, loss of the fees are all personal and direct to my clients. I see that my time is up.
Okay, you have some rebuttal, I believe.
Yes, sir.
All right, Ms. Wise.
May it please the court, my name is Tamar Wise and I represent the appellee Anshu Bhatnagar. The district court correctly found that the claims in the amended complaint had to be brought derivatively on behalf of M-Phase. The narrative that appellants have provided to this court is simply an attempt to fit a square peg in a round hole, trying to justify how their clearly derivative claims can be brought directly. But the court needs only look at the actual allegations of the amended complaint, as the New Jersey Supreme Court requires in this analysis, to see that appellants have no standing to bring this case. Certainly, the allegations that Mr. Bhatnagar engaged in dilutive financings or that he misused corporate funds not to pay off corporate debts, clearly those allegations of wrongdoing affected all the shareholders and therefore they must be brought derivatively. That does not seem to be in dispute. And the derivative action is the mechanism by which shareholders can protect and preserve share value in light of allegations just like this. And the purpose of it is to preserve company resources and to avoid multiple actions. That is what the New Jersey Supreme Court told us. But even appellants' arguments that they suffered direct or special injuries is mistaken here. And I want to be clear about which causes of actions we're actually dealing with. The breach of contract and breach of fiduciary duty actions as alleged in the amended complaint, clearly only allege that the wrongdoings that led to their injury were the dilutive financings and the corporate waste. Those are paragraphs 33 and 48 in the amended complaint. So those are clearly going to be derivative claims. And what we're left with, and as made clear by appellant's argument today, is the loan fraudulent inducement claim. But that claim too is derivative. The appellants here allege that they were provided with misrepresentations in the course of their negotiations with Mr.
I don't
Botnagar.
quite understand that. It seems to me if he has alleged fraud and, or they have alleged fraud, they were induced to give up their position in a company, give up salaries, to give up, to waive rights in exchange for what they thought Mr. Botnagar would do. And it seems to me that those aren't corporate injuries, are they?
Your Honor, I have a few responses to that. So I agree with the premise that that's if they did properly plead fraud, but separately speaking, the allegations of fraud here, if you look at what's actually...
No, stay away from that. I want to know about the damages, whether if he alleges fraud, my question was, it's a hypothetical. If he alleges fraud, aren't the damages he alleges direct damages and not derivative?
Your Honor, we don't believe so. The negotiations that were had between Mr. Botnagar and the appellants were in their capacity as the company. This was not, outsiders to the company being induced to invest in a company.
Positions. They gave up their salaries, they gave up their positions, and they altered their holdings or their relationship to the company in reliance on alleged fraud.
Your Honor, all of
Is
these...
that a personal damage to them?
All of these representations were made in their capacity as the company in furtherance of company interests with the intent, ultimately, to preserve the share price. That jumps off the pages of the complaint. What the appellants were concerned with was the preservation of the share price.
But what's... They allege that Mr. Botnagar made those representations to them personally, and that he's the one that induced them to change their relationship with the corporation based on fraudulent misrepresentations. And if there were fraudulent misrepresentations, it seems to me, if they relied on that and gave up some valuable position on the hope of a future promise gain, that isn't damage to the corporation. It's damage to them in the change in their position.
Well, Your Honor, ultimately what they wanted to get out of all this was a preservation of the share price. But what I think is most important to point out here is that appellants understand this to be a company loss. After briefing this appeal, several of the appellants turned around and filed a derivative action in Maryland State Court alleging the same allegations of wrongdoing, the dilutive financings, these alleged misrepresentations, and they bring the same allegations of fraud, breach of contract, breach of fiduciary duty, and negligent misrepresentation against Mr. Botnagar, brought by the same counsel. So in that derivative action that is ongoing, barreling towards a trial in January, the fraud count in that complaint says that the alleged misrepresentations were made to the company in breach of a duty owed to the company, and that the company relied on these misrepresentations.
Do they allege this? I'm sorry, go ahead.
No, go ahead. I was just going to say, can't both of those things be true? There can be misstatements made to the company before he became CEO on which the company relied, but you can also have individuals who were individually harmed. I mean, here, these debt equity conversion agreements were entered into in their individual capacities, and they could have individual claims for those particular damages. Now, maybe the way the fraud count is pleaded includes too much here, but they could plead, it would seem, an individual claim in addition to a company claim. You're not saying those are mutually exclusive, are you?
Well, Your Honor, two things. First of all, this amended complaint is with the benefit of repleading. After we filed a pre-motion request with Judge Grimm, the appellants amended their complaint, and what you see now is with the benefit of repleading. But second, I would submit that that subverts the purpose of the derivative action. The derivative action is meant to preserve company resources and to
So
avoid.
you're saying it is mutually exclusive. You can never have a claim, you can never have a fraud in the inducement claim brought by individuals as well as one based on misrepresentations to the company separately. I mean, there's separate agreements here, right? There's the transition agreement, which was entered into on behalf of the company, but these debt equity agreements appear to be personal.
Well, that actually furthers our point, Your Honor. The debt equity agreements were with the company. This is how the company was responding.
Right,
to
based on what they say were misrepresentations. They were induced to enter these based on promises that he never said he would keep, that he didn't intend to keep. It's hard to plead intent, obviously, to plead facts that support someone's state of mind, but they say he didn't intend to keep these promises.
Well, Your Honor, the entire purpose of these negotiations was for M-Phase to hire a CEO. This was an M-Phase negotiation to bring someone in, and the ultimate goal was to ensure that there were no dilutive financings. All of this, and again, this is...
So your position is that no matter how well they pleaded his state of mind, they just couldn't bring an individual fraud claim. This is all shareholder derivative. There's no way they could bring an individual claim.
On the facts alleged in this complaint, our position is that there are only derivative claims. And that's really borne out in
This is the paragraph I think is key, and you can tell me how you would read it. I'm looking at paragraph 39, which is part of the fraud count. And it says, as approximate result of defendant's fraudulent conduct, the value of plaintiff's shares in the company has declined significantly. That's where you're relying on, I think. And then it says, and plaintiffs have suffered additional substantial financial damages and a loss of legal rights. The question is, how do you construe that?
Well, Your Honor, our position is that they suffered those as part of the company's decision to enter into this negotiated agreement with Mr. Bhatnagar. All of these representations that they allege were made to them in the course of the negotiations, they were all then put into writing as part of a company agreement with Mr. Bhatnagar.
What's your best case, I guess, under New Jersey law for that proposition that on these facts, no matter how well pled, and of course there's a separate issue as to whether or not the fraud claims have actually been sufficiently pled, but if you assume they are, and they've alleged what they claim to be these separate damage components that are unique to them personally, what's the best case in New Jersey law that suggests that that doesn't matter and this is all derivative?
Your Honor, I would say it's the Strassenberg case. It's the New Jersey Supreme Court case from 1996. And that's kind of the foundational New Jersey case on derivative actions. And in that case, the court makes clear that even if there's a disparate impact on the different shareholders, when what you're talking about in essence, and I think it says specifically the essence of their damage is a dilution of the share price, and that is what we contend is being alleged here. Ultimately, what these appellants wanted to accomplish from this hiring of Mr. Bhatnagar was an assurance that the share price would not be diluted.
And that may be true for the run-of-the-mill shareholder, but I think as my colleagues have pointed out, these were not run-of-the-mill shareholders. They were officers of the company. They gave up additional valuable consideration, I guess, which was unique to them. And so isn't that relevant to make it different?
Your Honor, I would again point to the Strassenberg case and call it a disparate impact.
Was that a case involving officers who gave up something unique to them as opposed to the common shareholder?
There's no case that we found in New Jersey that has this exact fact pattern. And the cases that appellants cited on this fraud and the inducement issue, whether that can be brought directly or derivatively, those cases are in the very different context when an outsider to a company is induced to enter into it. When they're outsiders...
Just to focus that question a little bit, not on the general case holdings, but in this case, were the plaintiffs receiving a salary before these agreements?
They allege that they were.
Yeah. And afterwards, they did not, right?
They allege that they were no longer employees of the company.
Okay. So if they allege that they were getting salaries and that they voluntarily gave up those salaries based on fraudulent inducement, could they sue him in the person who alleged the fraud, Bhatnagar? Could they sue him for fraud?
On these alleged facts, I don't believe so.
On the facts I gave you, just the limited facts of they were induced to give up their jobs and their salaries by fraud.
Your Honor, I think what matters is in what capacity they were having these negotiations. If they were,
It doesn't matter. I mean, they personally gave up salaries. They got paid for a job. They resigned their jobs voluntarily in pursuant to promises or misrepresentations. Now, if it was fraudulent misrepresentations, my question really is, isn't that not corporate injury, but private injury, where a lawsuit would lie? I mean, I don't understand where the derivative aspect comes in when the injury is not to the shareholder or to the corporation, but this is now an injury to an individual executive.
well, Your Honor, as the allegations themselves make clear, this entire transaction had the intended goal of preserving Enphase share price. And so the appellants themselves allege that everything that they did as part of the company's hiring of Mr. Bhatnagar was with the intent of preserving the share price and ensuring that there would be no dilution. And so I would call that essentially an allegation of share price preservation. That was ultimately their goal and ultimately what a loss that had to be shared by the shareholders. It would have been a benefit that would have gone to all the shareholders had things not gone south. But I do want to point out that the appellants made this exact allegation of misrepresentations in their derivative action as misrepresentations to the company. And
Did they, someone may have asked this, and I'm sorry if I didn't catch it, but did they plead that in the alternative? Or?
they did not, Your Honor. So that is clearly a derivative claim. These are the same representations, and they're alleged to have been made to the company.
But can I ask you a question? I mean, we asked Mr. Costello some fairly pointed questions about the pleading of the claims, but that's not something that you really focused on, either apparently before Judge Grimm or on appeal. So do you concede that these claims have been pled properly?
We do not, Your Honor. Our focus is clearly on the derivative nature of these claims. We don't believe that appellants have standing. That's kind of a threshold issue. Judge Grimm agreed and dismissed it on the standing issue, but we did plead in the alternative.
Let me follow through a little bit on your theory, based on fairly on some of the allegations of the complaint. The argument is, I guess, that Bhatnagar made fraudulent statements to your clients, who were the executive crew of the company, in order to alter the course of the company's progress, financial progress. And as a result of that fraud, the company's stock went down, and that they're suing basically for the reduction in the shareholders' value.
Your Honor.
And that would be a derivative action.
Yes, Your Honor. That is our position. And it's born.
Well, that is alleged. And so the question is, are we to then read that type of a claim? Let's say I agree it's at this point for discussion that it's derivative. They add one clause and they say not only did they suffer loss of the value of their stock, shares in the stock, but other compensatory damages without specification.
That is what the Supreme Court, the New Jersey Supreme Court in Strasbourg says. There could be a disparate impact. And in fact, all these cases talk about potential other direct damages to shareholders. And I think you can always point to something like that. There are incidental damages that could be borne elsewhere, and that's why the Strasbourg.
Is it fair to call it incidental here? I mean, paragraph 14 of the complaint, they say prior management was not willing to transfer control, resign their positions, or agree to reduce or subordinate their debts without these promises, right? They make kind of the explicit allegation that these promises were made to them and they specifically relied on them and they would not have given up their positions and taken, this debt transfer if they hadn't been made these promises personally.
Yes, but as I think either in that paragraph or subsequent to that, the amended complaint makes clear that the purpose of all of this was to preserve the share price and ensure that there would be no dilution.
Why does that matter? Can't they be personally harmed? Can't they have an injury to their own interest that also, they were hoping that by doing this, that would benefit the company and shareholders would benefit too. But so shareholders might have a claim and they might have a claim. But again, I guess this just comes back to my mutually exclusive question. I don't quite follow your line of thinking that these can't coexist.
Your Honor, I would then go back to the court in Strassenberg's indication that you have to look at the essential injury that is alleged. And here we posit that the essential injury was the diminution of the share price. That was the injury that was ultimately what the appellants were trying to avoid in these discussions with Mr. Bhatnagar in terms of hiring him as CEO of the company. If the court has no further questions.
All right, thank you.
Thank you, Your Honor.
Mr. Costello, you have some rebuttal?
Yes, Your Honor. First, I'd like to address my colleague's arguments that there's a derivative suit has been filed. That is accurate, and it was filed simply because this matter's on appeal. We don't know when it's going to be resolved, and we had to file it to protect my client's rights.
I don't think she was faulting you for filing it. I think she was making the point that the fraud claim is a fraud caused to the corporation, and the damages were the diminution in the value of the stock, which would be a derivative claim.
Well,
And so, and the complaint seems to aim that way, although I've quoted sections that spin off from it, as has Judge Rushing. But it seems to me the question is, what is your complaint about the fraud? And you do allege, the only specific damage you allege is a reduction in the value of stock. And
respectfully,
you don't say loss of salaries or loss of position or anything else like that in your damage claim in the fraud suit.
paragraph 30 of the complaint outlines different categories of damages. And while I agree with Your Honor that there aren't specific dollar amounts for the share loss, the salary loss, the debt loss, the loss of voting control over the corporation, the loss of management control over a corporation, but they're all set forth, those different categories, in paragraph 30. One case that I think, one thing my colleague and I agree on is that the Strassenberg case is very instructive on this issue. And the reason for that is, on page 549 onto page 550, if you're using the New Jersey site, the Strassenberg case quotes to a shareholder derivative litigation treatise. And the court specifically cites to and puts forth an example of when someone would be able to bring a direct action as a shareholder for loss of value of their shares. And the example that they give is exactly pled in our case, where a director makes a specific direct misrepresentation to an individual shareholder. And in that context, the Strassenberg case says they may bring a direct action. That is directly on point. And those thoughts are echoed in the other Supreme Court New Jersey case, Tully, in which they say if you violate an individual duty to another individual, and everyone has a duty not to commit fraud, not to make misrepresentations to individuals, if you violate that individual duty that you owe to those individuals, then you may bring a direct action. And that's exactly what we've pled.
This is a minor question. I may have missed something, but can you help me understand how someone negligently misrepresents their state of mind?
I think the context would be testimony along the lines of this. I didn't want to hurt anybody, but I felt like I had to do it anyway, kind of thing. Where here we are saying, if Mr. Bhatnagar is going to take that position that he didn't mean to hurt anybody, well, then he was negligent because he didn't have a reasonable basis for making that promise, as evidenced by the fact that he turned around 3 months later or 4 months later and broke it. The other thing I wanted to point out, my colleague's making several descriptions about what the complaint alleges that I respectfully disagree with. We filed a complaint. The complaint's supposed to be read in the light most favorable to us. The complaint alleges that several categories of damages occurred here, not just the share loss. And again, if we focus on that Strasburg opinion and the specific example that they identify of a director speaking directly to a shareholder who misrepresents facts and the shareholder relies on that fact, the law of New Jersey says that shareholder can bring a direct action. The breach of contract claim is based on a third-party beneficiary theory that our clients, the shareholders, the directors, the management control, required that those provisions, that price floor provision, be in that transition agreement to protect them. The breach of fiduciary duty claim is not just based on the issuance of the convertible debentures, but the breach of fiduciary duty claim is also based on the fact that Mr. Bhatnagar, while he was CEO, was making active misrepresentations. Don't worry about these, I'm going to pay them off, and they're never going to be exercised. You don't have anything to worry about, and then does just the opposite. So, in summation, we have specifically alleged direct action. My clients want to pursue this as a direct action, and we feel like, the authorities we've cited and the facts alleged in the complaint satisfy the legal standard for them to bring a direct action.
All right, thank you, Mr. Costello. Appreciate your arguments. Our practice is to come down and shake your hands, and we're very proud of that practice. We have, during the pandemic, adopted a protocol where we're not doing that for health reasons. But when the two of you come back again someday, we'll shake your hand and we'll remember you were here. Thank you for your arguments. We'll proceed on to the next case. You're excused. Pollock versus Virginia Department of Environmental Quality, and Mr. Schulte, whenever you're ready, we'll hear from you.
Thank you, Your Honor. Good morning. May it please the court, my name is Tim Schulte, and I, together with my co-counsel, Sidney Raab, represent Elizabeth Pollock in a case against the Department for Environmental Quality. Ms. Pollock is suing DEQ under the EPA, claiming that she has been doing or was doing the exactly same job, substantially similar job as Henry Moon, but she was being paid far less. In 2017, her annual pay was $56,325, and in 2019 she was making same amount, $56,325. That is on page 192 of our joint appendix, while Henry Moon in 2017 was making $65,800. $800 and some dollars, and in 2019, $69,000. And the $69,000 is actually at a time where his work had been reduced by 10%. So if we add 10% to that, he was making $20,000 more than Elizabeth Pollock. The district court did not agree with us that the two were doing substantially similar work and dismissed the case on summary judgment. We're here because we think that was error. First, I would like to show the court what these two jobs actually were. And while they're called coastal planners, what they really are doing is they're grant writers. As their supervisor, Laura McCade, explains in her declaration on page 79 of the joint appendix, the National Oceanic and Atmospheric Agency of Federal Branch provides grant funding annually to the states, coastal states. And Virginia is interested in getting as much money of the federal grant as possible. DEQ is the designated agency, and DEQ has opened an office of coastal planners that is basically there to help all state agencies that are involved in trying to get grants with their grants. So if somebody in the city of Virginia Beach says we have beach corrosion, we would like to get some grant money, they call DEQ and say, how do I get some money? And then one of these coastal planners helps them create a grant application, put together the necessary data. They monitor the grants, and when these grants are provided, then the coastal planner monitors further and makes sure that they make timely submissions, if they need extensions, that they're filed on time, and such. On page...
Mr. Schulte, the district court in this case started out in its opinion by indicating that it's not enough simply to allege that two, in your case, your client and the comparator have essentially the same title, because that's not enough. And you've described what a coastal planner does generally, but the question is, do they actually, in fact, do substantially identical work? And the court identified 4 differences between what Mr. Moon did and what your client did that suggested that there was a substantial difference. What was wrong with that analysis?
Well, first of all, the 4 duties that the court identifies describe Mr. Moon's duties for one of his clients. He has 4 clients. VIMS, the Virginia Institute of Marine Science, is one of the 4. And then these duties were very, very small. For example, in the 18 years that Mr. Moon worked as a coastal planner, apparently he was involved in organizing 1 summit. In 18 years, 1 conference. That is not a core task, a core duty, as this court has held is the proper analysis. It's in 18 years, a weekend of a conference, and maybe it took 2-3 months to plan it, but DEQ neither quantifies the time, nor does it just pointed out here are 4 things that Ms. Pollock wasn't doing. As we pointed out in the joint appendix, Ms. Pollock had also organized a summit. Organizing a summit as a grant writer, we suggest requires similar skills and similar tasks. These people do not go out and do active research. They are there to make sure that their customers get the required federal funding. That is their job. And as far as that goes, Ms. Pollock, in her declaration, said the needs that VIMS had as a grantee are exactly the same as the needs that my customers had. There is no difference as far as my activities on this job. And so if you go through the record, For example, on page 85, that is the VIMS grant, and again, that we assume that's about 25% of what Mr. Moon was doing. He's in charge of, he grants management and he's in charge of grants management and reporting. He monitors activities on assigned grants. He drafts and finalizes grant applications. Page 85 and 86, he manages grants for Northern Neck, Richmond Regional,
Those
and
are all
Crater.
the similarities, and there are a lot of similarities.
Yes, sir.
But Ms. McKay, who was their supervisor, recognized that they were, had the same title. But she pointed out in her affidavit several tasks that were beyond what Ms. Pollock was doing and might not have been as capable of doing because of lack of experience. I'm looking at paragraphs 18, 19, and 20 of her affidavit. This is on page 82. And they all,
Yes.
it seemed to be a fairly disinterested affidavit. She recognizes the value of both employees, but then points out that because Mr. Moon had more experience, he worked on more challenging issues related to CZM program than Pollock and handled more difficult and complex grant application assignments. And then she went out to point out that he had responsibilities with respect to other agencies that Pollock didn't have. And then Mood had responsibility for research projects and conferences that Pollock didn't have. So the question, I suppose, that we're being presented is whether these are disputed, those differences. I understand the similarities, and the similarities you point out are meaningful, obviously, to the discussion. But I think if we're going to differential, we ought to be focusing on what is the differential, is it accurate, and then assessing whether that is substantially equal or virtually identical, which are the two standards we have for interpreting the word equal in the statute.
Yes, Judge Niemeyer. The problem with Ms. McKay's declaration is that she's focusing exclusively on the VIMS grant. Her declaration assumes, and falsely assumes, that Mr. Moon is working on these duties 100% of his time. He's not. He's working on it 25% of his time. He's spending the other 75% on his other accounts. So when she says he's doing these 4 duties and there's a certain percentage
It's not a
assigned to him.
percentage. She didn't assign percentage. I'm focusing on the notion that he did more complex and more difficult assignments because he had more experience. Now, if you have 2 persons doing grants, and let's say they're doing nothing else but grants, and one is doing a level 1 grant, and the other is doing levels 1, 2, and 3 grants in terms of difficulty, then you might want to pay the one who's doing level 1, 2, and 3 grants more than you pay the person who's only doing level 1 grants. That's just sort of my hypothetical, and I'm posing that question to you because that, to me, is sort of at the heart of where the district court focused.
Yes, sir, but Ms. Pollock in her declaration says, I was working with some Native American tribe, and our challenges were similar to VIMS. I have done exactly the same work, and this is not, I know that the district court called her declaration unsubstantiated and self-serving, and because of that, completely ignored the declaration. We think that's error, as this court.
Well, except that Ms. Pollock, while being, I'm sure, being genuine and trying to explain in detail her job, is unable to compare that to Mr. Moon's job, who she doesn't know all of what he does and where he does and what assignments he gets. The person who does know both jobs is Ms. McKay. And Ms. McKay gave credit to both employees, but did say there was a difference in in the level of the work that they did. And that seems to be unrebutted. That's sort of the heart of the matter here, because we're dealing with a statute that says equal pay, and we have interpreted that the comparator under that standard can't be perfectly equal. We recognize that, but it has to be substantially equal or virtually identical, the two jobs. And I think Ms. McKay presents some difficulties in that regard for you, isn't it?
Well, Your Honor.
I was looking at page 82 as where her
I'm
declaration.
sorry?
I was, in case you wanted to see where I was looking, it was page 82.
Yeah, I'm trying to find Mr. Moon's work profile to show you the percentages for the duties that Ms. McKay identifies. First,
Let me ask you this. What if for 75% of his job, he was doing the same job as Ms. Pollock? But for 25% of his job, he was doing a much elevated job. He was doing more advanced policy making. He was doing different types of conferences, even different types of work. And let's assume that. It's hard to conclude that those two persons have equal value and equal pay to the employer.
but that is not this case, Your Honor. And first of all, Ms. McKay says the one statement on page 82, paragraph 18, he handled more difficult and complex grant application assignments. She doesn't substantiate that. That is just her conclusory statement. Well, and Ms. Pollock denies that and says, I know what he's doing because we talk every day. Mr. Moon and I, we sit in the same office, we coordinate everything we do, we're constantly discussing our workload, and I know exactly what he does, and he knows exactly what I do. And so this one statement, which she just says he does more than she does, but she doesn't explain how and what
Well, she
percentage.
said more complex and difficult applications, and she says that she assigned those to him because he had more experience.
That's true, but that doesn't.
That's a little different from what you were just saying.
Well, but it doesn't show why and how these more complex jobs require tasks or skills that Ms. Pollock would not have. Ms. Pollock says in her declaration, I could have done all the
Well, that
tasks
isn't the test, is what she had, the skills she had. It's the work she was performing. It's equal pay for equal work. And so we have to look at what she actually was doing. So if she was as smart and maybe even smarter than him, but she was giving level 1 grants and he was getting level 1, level 2, level 3 grants, the work would be different, even though she may have been capable of doing level 2 and 3. She wasn't doing that work, and so she could go in and say, give me level 2 and level 3, and then pay me comparably. But I think the question here is what she was actually doing, isn't it?
And sir, if we had that kind of specificity in the record, my argument, my position would be more difficult, but we don't. We do not have anything. DEQ has no records that say that Mr. Moon's grants were level 2 or level 3 or level 4. There's nothing. All we have is these 4 words there, it is more complex. And Ms. Pollock says, no, they're not. I know what he was working on, and we were doing exactly the same work and working to the same standards. The district court also comes up with hypothetical, what if a grant, and basically not follows your example, but has a similar example saying, what if a customer is more stringent or more difficult than another customer? None of that was in the record. And under a summary judgment, we get inferences. DEQ does not get these inferences. And what the district court put together ignores all of our evidence and makes inferences out of thin air that were not anywhere in the record. All we have is this one statement in paragraph 18 of Ms. McKay's,
Well, you have 19 and 20 too.
but they're not, well, if you look at his records, the National Estuarine Research Reserve Systems, these are minute percentages of his workload. They're 3% of 1/4 of his work. The core responsibility that he and Ms. Pollock had was helping people get grant money. And these grantees had the same needs as Ms. Pollock's needs.
Mr. Schulte, can I ask a question about the evidence in the record? So it doesn't appear that we have evidence specifically about Mr. Pollock's grants, other than we don't have the sample grants, for example. We have descriptions of what they do. And so your client says, as you point out, that I know what he's doing. He does the exact same thing. We talk about it all the time. But why isn't the evidence of the sample grants that Pollock is working on in the record? And if it's not in the record, does that hurt or help you?
Well, I think it helps me. First of all, there are about 70,000 documents in this case that were produced by DEQ. When DEQ filed its motion for summary judgment, they did not attach any grants, and we didn't find it necessary to attach any to our summary judgment memoranda. So that, I don't think they brought that up as a topic. What we're relying on is basically the job descriptions, and there too they have very little, because until the day of summary judgment, DEQ had taken the position, Mr. Moon is not our employee. And so they have very, very few employment records of his. They have income-related, tax-related stuff, but they don't really have an EWP as they do for Ms. Pollock, for example. They don't have these documents for him.
Okay. I have one final question for you that I know is not necessarily relevant to the appeal here today, but isn't a legitimate distinction between your client and Mr. Pollock just the numerical difference in years of experience? And if so, when does that become relevant?
Well, sir, under MIA, that would be relevant when we come to the affirmative defense. It's not part of the comparison of whether they have equal work. I see my time is long enough. I would like to reserve the last minute.
It's been an interesting discussion. We have you back on rebuttal.
Thank you, sir.
All right. Mr. Muse.
Good morning, Your Honors. My name is Brian Muse, and I represent the Virginia Department of Environmental Quality, or DEQ as it's normally referred to. Your Honors, the district court did not err in granting summary judgment to DEQ in this case. Contrary to Ms. Pollock's framing of the issue as the district court creating some new or grand pronouncement that the EPA is not available to white-collar employees, or that the evidence was ignored, the district court's decision simply follows summary judgment standards in Celotex and the Liberty Lobby case. The issue of proving that there was a male comparator to Ms. Pollock who performed substantially equal, not substantially similar in the context of a Title VII case, but substantially equal work, which has been defined by this court in Spencer and Wheatley and other cases as virtually identical. That is Ms. Pollock's burden. The court did not say that in no situation where you have coastal planners working with different tasks, different stakeholders, could you ever have an EPA claim. What the court held was that the plaintiff in this case failed to satisfy her burden of demonstrating that evidence. Your Honor, just briefly, since obviously the facts are certainly in the record, DEQ does wish to respond here initially to the statement that on the eve of summary judgment, somehow there was a change in how it recognized Mr. Moon's position. Now, that is not the case. Mr. Moon was hired through the Virginia Institute of Marine Science, which is part of the College of William and Mary. They obtained him as a coastal planner. with respect to his employment status with DEQ, all DEQ has recognized that for purposes of summary judgment and undisputed facts, that there's not undisputed facts that demonstrate that he was not a joint employee. So DEQ has not, during this litigation, changed its position, just merely recognized what the status is for summary judgment. With respect to that, Mr. Moon was hired by VIMS, Virginia Institute of Marine Science, which is a subrecipient of these grants that are provided by NOAA, the National Oceanic and Atmospheric Administration, to coastal states. And there's other subrecipients as well. So DEQ administers these, and there's a variety of other subrecipients, including VIMS. But ultimately, as stated, plaintiff Ms. Pollock failed to carry her burden because what she was relying on was attempting to create a comparator at a high level of abstraction versus actually going, as Wheatley says, factor by factor. What is not contested is, in fact, admitted in response to, for example, in response to DEQ's statement of an undisputed fact, paragraph 24. Ms. Pollock admitted that Moon was solely responsible for 4 of the VIMS grant deliverables that accounted for approximately a third, somewhere between 32.5% and 37.5% of the budget and the grant, but also Moon's time, how he spent his time. And that was not disputed. Again, Your Honors.
Okay, so, I mean, they don't have to be virtually identical, right? There can be some differences. Do you think that that standing alone is enough to warrant a grant of summary judgment?
Your Honor, respectfully, I would disagree that it doesn't have to be virtually identical. In the Spencer case, this court defines substantially equal as being virtually identical.
So one difference in a job description is enough to kick a plaintiff out of court?
Your Honor, I would grant the court that certainly one job description, if it wasn't significant, because again...
Well, that's what I'm asking. Is this significant? And if so, why is it?
Well, this goes towards, for example, in Wheatley and Spencer, where they discuss how the manner of how the work, the manner of the work can be similar, whereas the actual duties have to be equal. And whether one duty, if it was minor, certainly, if a duty was minor, certainly, I think the district court recognized that, saying, again, there's no broad pronouncement concerning, oh, coastal planners could never be substantially equal. But here, it is not just one difference. It is conceded, for the record, that a third or over a third of Moon's duties and the time he spent with respect to this grants for the VIMS grant was different. And DEQ would certainly argue, Your Honors, that that is for Equal Pay Act purposes, perhaps unlike Title VII purposes, but for Equal Pay Act purposes is significant enough to prevent a plaintiff from establishing a prima facie case.
Mr. Schulte says that that's just one grant and that you take that in isolation. That shouldn't be the sine qua non of whether or not these parties are on equal footing when it comes to their job descriptions.
Yes, sir. But again, I think Ms. Pollock's argument in some ways turns the burden here on its head. Much of the argument is, well, DEQ didn't do this. DEQ didn't do this. What DEQ did was demonstrate that 4 of the duties, approximately a third of his time, were different. Ms. Pollock responded by saying, well, we're coastal planners. We both do, as Kirk Counsel said today, we both do coastal planning work. We do grant funding work. And
So I'm sorry to interrupt you, but the duties might be different, but if they're qualitatively the same, wouldn't that, I mean, it seems like that's what she's arguing. Yeah, we did different things, we had different grants, but the core function was qualitatively the same.
Your Honor, I think that also gets to the heart of the Spencer case, where in that case the plaintiff argued our duties are qualitatively the same. We're both professors. We have responsibility for teaching college students. This is the Spencer versus Virginia thing. teaching classes, preparing syllabi. We are governed under the same standards. And certainly, as the court in Spencer recognized, those were similar. I mean, qualitatively similar. But respectfully, Your Honor, if I'm disagreeing with you, we would posit
Wouldn't be the first time, but go ahead.
Thank you, Your Honor. We would posit that that substantially similar is not virtually identical or virtually equal. And again, this court did not ignore Ms. Pollock's evidence or refuse to consider it. The court considered Ms. Pollock's evidence, including her declaration. And as noted on brief, the court also did not, in a wholesale way, conclude the court's just not going to even acknowledge this declaration. In terms of statements that the declaration was self-serving, that related only to portions of the declaration concerning essentially conclusions of law, saying, well, our jobs are substantially equal. We did virtually the same thing, which is a legal conclusion that, of course, has to be underpinned by the facts in the case, whether that demonstrates it or not. But the undisputed material facts related to these differences, Ms. Pollock's statement related to differences. Ms. Pollock characterized them as differences based on experience. But the reality is, regardless of the reason, there was no question that there were differences in what they did. Ms. Pollock, in fact,
you were relying on the VIMS grant, which was a substantial part of his time. Was that grant different from other grants on which, say, Ms. Pollock worked on?
Your Honor, there certainly were differences in these grants, and I think that's set in the record. For example, Mr. Pollock's work collaborating with the Chesapeake-based Sentinel Site Cooperative, preparing and handling marsh vulnerability studies. Your Honor, I think that gets to the point, is that DEQ offered specific evidence in terms of these differences, and that it wasn't rebutted, and in fact, it was admitted in many cases. In fact, this court can only look to Ms. Pollock's own statements. In many ways, she summed this up best when she admitted that she had no responsibilities with respect to the VIMS grant, in the same way that Mr. Moon had no responsibilities with respect to her clients. For example, the Virginia Department of Conservation and Recreation.
So what is it about, okay, so let's say that the record is limited to that. He works on grant A, she works on grant B. She claims that they're qualitatively similar in the sense of the extent of the work that's to be done. So is it simply a subjective, decision by the employer that I think this work is more valued than that?
Well, Your Honor, at the prima facie case stage, I think certainly in terms of the value, that could go towards an affirmative defense in terms of the reasons for a salary differential. But here, it is not an issue of a subjective case of whether certain work was more valuable than the other. What DEQ relied on, and what we contend the district court relied on, was the fact that they were different. Certainly from an EPA substantially identical standpoint, that the work is different.
Well, to follow up a little bit on this question, was work being done on the VIMS grant different in kind than the work being done by, say, Ms. Pollock on another grant? In other words, was it the same work or was it different work? I'm not sure that it gets you very far just to have a different benefactor, a name. It's like having a different customer in a business. The question is, if you're serving customer A and the work is more complex and different than the work you serve for customer B, that seems to be a valid point to make. But if you're serving customer A and customer B with the same type of services, and one worker's doing A and one worker's doing B, that may not help much.
Your Honor, I think certainly, and I think this gets to the issue of Spencer
Well,
in terms of,
before you get
oh,
to
excuse
Spencer,
me,
I understand, Spencer. I want to know what the record shows about the nature of the VIMS grant as distinct from other grants.
well, the record, and it would point to Ms. McKay's declaration and testimony, does show that these were different. For example, in her deposition, which is in the record, I apologize, I don't have a page, but in her declaration, which is also on brief, she was asked, well, didn't Ms. Pollock also do these same duties on Section 309 of the grant? And she responded, no. She didn't have the same qualifications, and based on his years of experience, for example, to do with respect to coastal impact work, whereas it may have been in the same grant, but she was doing land conservation work. And Ms. McKay offered testimony where there was no facts to rebut it, no evidence to rebut it, that this was different work and required more skill. And Your Honors, I think this difference with respect to jobs like these, and I mentioned Spencer, and Your Honor, I apologize. I wasn't trying to avoid answering the
No, I
question.
understand, Spencer, and your answer is, if I understand it correctly, is that doing coastal management is a different task and perhaps more difficult than doing conservation on land, which is also under the grant. And that's what I understand your point being.
Yes, Your Honor. Okay. And her burden,
That answers my question, yes. Yeah.
And her burden, once these facts are presented, to rebut that, since it is...
Yeah, the prima facie case,
Right.
I mean, has the requirement that she make that as part of her showing.
And DEQ does believe that this case does need, there's many cases cited between the two briefs, that it does need to be taken in light of the nature of the work. And that's where I mentioned Spencer is starting to answer a moment ago, that these types of cases, these types of jobs that require a high degree of intellectual creativity, whether it's academic, this is science in nature, although certainly Mr. Moon's job was through William & Mary, which is part of VIMS, but whether it's science or academic, that what Spencer holds is that those jobs in particular really need to be addressed and viewed on this very factor by factor level, because it is something where the creative process and the specific nature of the work and the sophistication of the work is perhaps different than, for example, many of the cases cited by Ms. Pollock. It's notable that while there's a voluminous number of cases cited in her briefing, many of these cases, perhaps virtually all the cases, relate to, for example, individuals performing work where in the Hodgins versus Fairmont Supply Company, where somebody was saying, well, my job working in the middle of a section of a stock desk is different than the two women who were working on the outside of the stock desk. Unlike this case, many of those cases also involve what we would refer to as the more work case. In other words, whereas opposed to saying, well, these are different types of work in terms of, for example, unlike two college professors that are both college professors but are doing different types of work, cases, for example, where you have the Brennan versus Prince William Hospital case, which plaintiff cites, which is a case where in 1972 the hospital had a policy where it only hired male orderlies and only hired female nurses' aides. But somewhat remarkably, that wasn't actually the issue of the case, that we had this sex-specific job hiring criteria, but it was an allegation that, well, because male orderlies maybe had more duties with respect to restraining patients, that's insufficient. Doing the same thing and just a little more of it is different than was at issue in Spencer and what was at issue in here. And the court held, again, much like Spencer, that many of these allegations of similarities, grant writing, For example, strategic planning.
Your case rests on the notion, at least in addressing Pollock's affidavit, the notion that all grants aren't the same, just as all professors are not the same. That some grants are more difficult to handle than others, and it's more complex, maybe larger in sums and so forth. Is that how I understand?
Yes, Your Honor. It absolutely is. And if Ms. Pollock wishes to demonstrate that the jobs were similar, that the actual grant work was not similar, but substantially equal, virtually identical, that is her burden. And that is what the court found that she failed to do, instead choosing to rely on viewing the jobs at more of this high level of abstraction. Well, we're all grant planners. We all do strategic planners. We all work for clients related to things like coastal planning matters. This is simply insufficient under the Equal Pay Act for her to carry her burden to establish a prima facie case. Your Honors, for these reasons, DEQ would request that this court affirm the judgment of the district court, granting summary judgment to DEQ based on a failure by Ms. Pollock to establish a viable male comparator.
Thank you, Mr. Muse. Mr. Costello? Excuse me, Mr. Schulte. Mr. Costello was in our last case, and the two of you are quite distinct.
Apology accepted, Your Honor. I would like to very quickly go back to Ms. McKay's declaration on page 82. In paragraph 18, she says, Mr. Moon handled more difficult and complex grant applications. In 19, she talks about responsibilities for the National Estuarine Research Reserve System, NERS. If the court looks at page 86, which is the grant, the VIMS grant that financed Mr. Moon's position, it shows the duty regarding NERS. It is on page 87, product number 12. It is assigned a 5% value of the VIMS grant, not of his entire time, of just the work for VIMS. So if that's 1/4, that's a 1% part of his work.
I tell you, I'll try to share with you what my concern is and let you try to address it head on. In Spencer, which is a pretty good precedent for us to apply here, because here we have two coastal planners, and there we had two professors. And if you describe a professor's job, two professors are basically doing the same thing. But not all professors are the same in experience, quality, evaluation. And we made that point, and it seems to me, if it turns out that the VIMS grant and some other grants are more difficult and complex than grants handled by Ms. Pollock, that's a full professor versus a assistant professor who's less experienced. In other words, I'm not focusing on the title, they could be both full professors, but the question is, are we looking at the same job, the same work, and the people well placed to evaluate whether they're doing the same jobs are the people that supervise them. And in this case, we don't need two different supervisors to compare notes. We have one supervisor who knew of both their works and said there is a difference, a material difference. And now the question is, if there is a material difference, how does Ms. Pollock challenge that? And you can challenge it as a matter of law like you are. You're saying 5% is not enough or 10%. But that isn't the issue. The question is that the standard we've used is either substantially equal or virtually identical. And clearly, if we have 35% of his work is on the VIMS, and that's a difficult and important grant, which does coastal environmental work, as distinguished from what Ms. McKay said is less difficult, that is land-based environmental work. There's a difference right there. Now, I don't know if we have to make a judgment about that difference, but the people that hired her thought it was different. And the question is, are they being reasonable, or is that just a sham? Is that a pretense? Was she saying that they're different work?
Your Honor.
And it's, as you see, the problem we're having is it's a tough standard, and the question is, I suppose, what makes coastal workers, planners, same, and what makes them different?
Your Honor, this court in Spencer said professors are not widgets. The physics professor cannot
We're
teach
trying to point
sociology
out that
class.
they're not fungible. One professor is not the same as another.
These two people are fungible.
Well, Ms. McKay said not so.
The Hampton Roads project, one huge customer was moved from Mr. Moon to Ms. Pollock, and there were no difficulties
Judge Niemeyer
whatsoever.
is correct here. Ms. McKay said they're not fungible. She said Ms. Pollock doesn't do and can't do coastal hazard management in the way that Mr. Moon can. And there's other differences in what they do. We have in the record the amount of the grant, the amount of money that Mr. Moon was managing. I did not find any evidence in the record about how much Ms. Pollock is managing. If anything, there's a lack of evidence for us to make this comparison, and that falls on you.
Oh, Your Honor, I don't think there's a lack of evidence. If you look at the VIMS documents, the differences are based on duties that take up a minute amount of time of Mr. Moon's work. This is not his core task. I'm sorry?
How do we know that?
Because on page 87, it says Coastal Partners Workshop, 5% of the VIMS grant. Program representation about the National Estuarine Research Reserve in Virginia is product number 12, 5%. Those are the two main differences Ms. McKay rests on. They are together 10% of a 25% account.
That's of the grant, but he worked on the entire grant. He spent a third of his time on that grant.
Well, we don't know about a third of the time.
I thought that's what, I thought it was 30 to 38% or something of his time on the VIMS grant.
That's not the VIMS grant. That are certain aspects of the VIMS grant. That is where DEQ delineates certain duties, and that's 37% of the VIMS grant. That's 8% of his work. I know my time is long up.
Oh, I'm interested in hearing.
Okay.
If you have a point to make, I'll give you one more minute to wind up. Yeah.
Thank you, sir. Spencer is limited to the university system. We have listed, I don't know how many, 24 cases about fraud investigators, female nurse practitioners, anesthesiologists, university fundraisers, librarians, newspaper photographers, directors of sales, bank managers, vice presidents from medical research centers. These are highly intellectually challenging jobs. It is not that the EPA is closed for white-collar workers. We ask that the court vacate the order and send this case to trial. Thank you very much for your time.
Thank you, Mr. Schulte. All right, I want to thank counsel for their arguments on behalf of the court. We would normally come down. You know, I don't know if you know the history of this, but back in 1930s, Judge Parker came back after his defeat for the Supreme Court position. He says he's going to really give his attention to the Fourth Circuit, and he created the Judicial Conference, and he created the notion that district judges newly appointed sit with the court so we get to know each other. And he created the handshake, which we come down and shake hands with the court and the bar, and it's a wonderful tradition, and I think we're all set on keeping it. I think we're the only court that does that, and we don't give it up lightly, but as you know, the pandemic has caused some changes, but this is our virtual handshakes to you, and thanks for your arguments. So we'll adjourn court for the day.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.